Nicole, good morning or afternoon, everyone. Real pleasure to speak to you all today on this webinar. As Nicole said, I'm joining you from FRA's Dubai office, where I've been for the last year, just over, having spent most of my time, most of the last over 7 years now at FRA, based in the London office with one of my colleagues who's on the call on the webinar today, Alejandro. So as I say, I've been a partner now at FRA for over 7 years. I come from a legal background, having worked over 20 years now in investigations, financial crime and regulatory inquiries, and now working at FRA in a consulting capacity. So what we're talking about today, it's a very current, fast-moving and interesting topic, which I'm pleased to be joined by FRA directors, as I've mentioned, Alejandro, who's from our London office, and also from Masako from Washington, DC, who are here to discuss compliance challenges, technological solutions, and also risk management around ephemeral and off-channel messaging. So since we're going to be using these two terms quite a bit during the course of the session today, I thought it would be helpful just to very briefly define what we mean by each of these two terms. So ephemeral messaging, and I'm sure lots and lots of people know this already, but just to kind of recap, this refers to communications that are designed to disappear or to become ordinarily, and kind of underlining that word for the moment, ordinarily inaccessible after a certain period of time. The messages are not, or at least not intended to be stored permanently, and often include features that enable the message to be deleted automatically, either after it's read or within a time after it has been read. There are lots of examples in the marketplace. I'm sure many of you have used some or all of these, and they include, of course, things like Snapchat, WhatsApp, which now has these features, Signal, and also iMessage, which has, if you hold down the blue arrow when just after you've typed a message, you'll see that there's an invisible ink feature on iMessage, which is essentially their ephemeral messaging option. So that's ephemeral messaging. Off-channel communications, which may or may not include in itself an ephemeral element. So this refers essentially to any form of communication that occurs outside of the official sanctioned channels of an organization. Obvious examples of this are corporate email, your corporate Teams account, or the Zoom account that you use as part of your workplace activities. So anything outside of that, we refer to off-channel communications, and the types of communications that are not themselves systematically monitored, recorded, or controlled by the organization's IT department or by the organization's communication policies. So examples of that obviously include personal email, text messaging on personal phones, or other forms of social media. So those are the two concepts that we're talking about today. So having talked through those a little bit, let's get on with the agenda for today. So the first thing that I wanted to cover was just to go through the kind of complexities and risks that come up when off-channel and ephemeral communications are used in organizations. So we all know, I think through our own experience, that the use of off-channel communications and ephemeral messaging had been steadily increasing for a number of years as people took advantage of these to make their work life easier, more efficient, and to cope with the ever-increasing volume of traffic that one has to deal with in one's working life. But what is now clear, both experientially, but also from a number of studies that have taken place, is that the pace of change of adoption of multiple messaging platforms increased and became much more widespread during the course of the pandemic, as businesses essentially, as we all know, had to change practices practically overnight. And now the move post-pandemic has been to a mostly hybrid working environment where many of these changes have now essentially been baked into day-to-day working practices. It's worth just taking a moment to reflect back on what it was like before the pandemic. Although these messaging applications were on the increase, many off-channel communications that were both off-channel and potentially ephemeral, and by that I mean just simply forgotten, were those sorts of moments by the water cooler, where you're discussing things with colleagues, discussions at the side of a desk, which are not part of a formal meeting where someone might be taking a note, or just chats in a bar or a restaurant when you're either traveling for work or just after work. These were all communications that took place kind of off-channel, and was largely kind of accepted by organizations. But what's different today, what's different now, is that almost all of these conversations, perhaps sometimes now as a default, take place across messaging platforms instead of in that kind of informal setting that we were perhaps used to some years ago now. And I think now that is a default because of the permanency of hybrid working, and also the ever-increasing choice of messaging platforms that have features that make things easier and more convenient for people. And just as an example of how those changes have kind of baked into the work environment, you, like me, you may have experienced colleagues when you are working in the office who might be just sitting a few desks away from each other, but prefer or default to sending a message via a chat mechanism, rather than actually standing up and walking a few desks away to speak to somebody. So it does seem to be very much kind of a thing that's here to stay, and that we have to kind of adapt and deal with. And of course, all of these changes have not gone at all unnoticed by government enforcement teams and regulators, who have clearly sort of sat up of late and taken notice of the changes, and have been sending very clear signals. That's not intended to be a joke, by the way, of the need for organizations to do much better in capturing the totality of communications between employees and third parties on any business-related matter. So I think the other point just to note before we move on to the what's been happening in the regulatory and enforcement space is to also kind of just note that, as well as using messaging platforms for convenience sake, sometimes they are also used as a way of providing cover for communications on matters that might relate to a breach of company policy, or perhaps even some form of unlawful activity. And we've observed through successive enforcement cases that regulators and prosecutors are, I think, now fully alive to the fact that employees today sending inculpatory messages via company-approved communication channels is pretty close to nil. All the juicy stuff, the real story, if you like, will be set out in the WhatsApps, the Signals, the Telegrams, the iMessages, and all the corporate email will provide is a partial and heavily sanitized version of the facts. So these types of messages are, really important and are extremely high on the wish list for any regulator or prosecutor if you happen to come on the crosshairs of some kind of inquiry. So if I just move to the next slide now and just talk a little bit about some of the developments and the implications from some of these developments before Masako and Alejandro jump in and talk through some of the practical solutions to manage the risk from a compliance perspective and also from a technological perspective. So one of the developments that we've seen over the last few years is a much more active enforcement landscape, particularly for financial institutions who are under positive obligations to preserve all business-related communications as part of their regulatory environment. And you may have seen, and it's a couple of years ago now, but or just under that in September 2022. 16 Wall Street financial institutions collectively received fines of over $1 billion for failing to preserve text messages in a practice that was described as widespread and long-standing failures by the firms and their employees to maintain and preserve electronic communications. And for some of those 11, who were also regulated by the CFTC, or Commodities Futures Trading Commission, also settled with 11 of those 16, ordering a further 710 million for failing to maintain and produce records, and also failing to comply with their regulatory requirements by failing to diligently supervise matters relating to their business activities. So really serious implications for financial services institutions who come up against regulatory inquiries on failing to preserve records. The second development, which really applies both to corporates and regulated entities alike, and this comes in the form of updated guidance from prosecutors and regulators, including particularly from the DOJ, responding to the increased use of off-channel messaging and ephemeral messaging. So an early example of this was the DOJ's, Department of Justice's Monaco memo, which was followed up more lately in March 2023 by some fairly significant revisions to the DOJ's evaluation of corporate compliance programs to cover their expectations on off-channel and ephemeral messaging communication platforms. These developments have also been punctuated by several speeches and remarks by the regulators and the prosecutors, intending to underscore and bring to life the importance of these duties and obligations in the preservation and retrieval of business communications, and also the implications of failing to do so. And I think where we get to in terms of the bottom line of all of this, and Misako will expand on this a little bit when she takes the baton, is that whilst there is some degree of flexibility afforded to companies in how they handle these issues in the guidance, I should say in the guidance and the speeches that have been made, it is clear that this will be fairly strictly confined, and ultimately any failures to meet the preservation and production expectations will result in a significant reduction in the cooperation credit that prosecutors will give when negotiating any plea or settlement for the company, which could impact not just the size of any fine or disgorgement that's imposed, but also the terms of the settlement, which might in some cases involve the requirement to appoint an independent monitor. And I think whilst it's true that the US has been leading the charge in this area, as is often the case in other areas, other similar areas, these developments are being mirrored and followed across other jurisdictions, including in the UK and also across the European Union. And I think what we find is that obviously these developments have been around now for some time, and these new messaging applications have been around for some time. But it's absolutely an area that our clients still struggle with and find challenges with, and we think this is partly because the working practices have changed and continue to change and continue to remain hybrid. But I think there's also the constant movement of in the availability of new messaging apps, different features, and the innovations essentially in technology that come alongside these, which can cause or require companies to move with fleetness of foot in order to be able to deal with them. And then also, lots of companies that we are lucky enough to help work across a number of different geographies where there are very different practices locally, different data privacy regimes and requirements, and these also bring with them considerable challenges that companies need to be able to combine into their policy and framework. So given all these challenges, we wanted to share some of our experiences and come up with some practical and pragmatic solutions. So later in the session, Alejandro who's from our forensic technology practice, we'll look at the technology solutions and what's out there that can be leveraged for you. But for now, what I'm going to do is pass on to our forensic accounting director, Misako, who's going to look at what implications there are for compliance program design and effectiveness, and how best to calibrate the program to align as closely as possible with emerging guidance and to help clients minimize risk. Masako's worked on various forensic investigations over the years, including monitorships that have centered around the remediation of corporate compliance programs over her career. So we're in good hands. And over to you, Masako, to take the next few slides.
Thank you, Simon. Hi, everyone. I'm Masako, and I'll be discussing the current guidance that is available and our interpretation of it. As Simon discussed, the regulators are aware that trends are evolving, and companies often adopt new technologies in their business. In recent years, the US regulators share their expectation about technology involving ephemeral messaging applications and companies' ability to produce documents when companies are using that technology. In this section, I will first discuss the US Department of Justice and US Federal Trade Commission's guidance regarding the ephemeral messaging, their view of ephemeral messaging application, which was updated in January 2024. In particular, they are reinforcing their expectation during government investigation or litigation that companies and individuals have a legal obligation to preserve and produce any and all responsive documents, including data from ephemeral messaging applications. In other words, if companies and individuals fail to produce such documents, the DOJ and the FTC may view that act as obstruction of justice. Even if they don't view that as severely, their view of the matter can be impacted, which makes it important for companies to ensure that they are equipped with appropriate solutions. As Simon spoke earlier about the DOJ's evaluation of corporate compliance program being updated in March 2003, we know that, I think, and many of you here today are aware that it is a hallmark of corporate compliance program. The DOJ recognizes the wider use of messaging application for companies' day-to-day operations, including ephemeral messaging features. The updates of ECCP specifically focus on two areas when it comes to ephemeral messaging: policies and procedures, and risk management. First, in evaluating policies and procedures, including mechanism for identifying, investigating, reporting, and remediating potential misconduct, the DOJ will focus on if existing policies allow the use of personal devices, messaging applications, including ephemeral messaging, and whether policies are tailored to the risk of the company. The DOJ will also evaluate how the policies are communicated to employees, where the training was provided, and how the policies are being reinforced. For better or for worse, the reinforcement intertwines with companies' posture and approach when there's potential or actual misconduct and violations, how they investigate the matter, and any disciplinary action taken as a result of investigation, even if they were honest errors. Such potential misconduct and violations, whether confirmed or not, should prompt the company to reevaluate current policies and procedures and the needs for conducting risk assessment for certain risks. Second, as just alluded, the regulators expect companies to consider various risks and how they affect the company's operations. In the updated ECCP, the DOJ uses an example whether a company has considered the use of personal devices, also known as a bring your own device or BYOD policy, or use of messaging applications, including ephemeral messaging features. If allowing BYOD and use of ephemeral messaging, companies should consider the impact of this has on compliance program and its ability to conduct investigation or respond to requests from prosecutors or regulatory agencies. In other words, the benefit of these technological features should not impair the company's ability to conduct day-to-day operation in a compliant manner. Regardless of the company's decision, it is important that policies are tailored to the needs and utilize risk-based approach that is fit for purpose for each company's unique operation. Outside of the US, the discussion regarding ephemeral messaging is ongoing. In the UK and the EU, rules still require companies to retain certain business records and personal data for some time. For example, Financial Conduct Authority, FCA, in the UK requires certain communication to be recorded on business devices, and the financial records need to be preserved for 6 years. Privacy laws such as GDPR can make the regulatory development in this area particularly challenging, especially if business is conducted on personal devices, whether the policy permits or not. In terms of regulatory actions today, Simon discussed an increase in cases related to off-channel communication in recent years. In March 2023, Corsacol, a coal mining company based in Pennsylvania, received a declination letter from the DOJ. This was an FCPA matter involving the use of encrypted messaging device to discuss bribery schemes among the company executive and co-conspirators. The DOJ has since then praised Corsacol for its timely, voluntary self-reporting and its ability to fully remediate the misconduct. Today, Corsacol is an example that DOJ keeps referencing as a success story. From what we have seen today, the regulators will keep the guidance high level and let companies decide what works for them individually. Companies need to keep their eyes peeled and learn from others' best practice as well as from their mistakes. Now I'll be passing on to Alejandro, who will be discussing practical steps and technology solutions.
Thanks, Misako. Hi, everyone. I'm Alejandro, and today I'll be discussing some of the technology solutions for managing ephemeral messaging, what's out there at a high level, and the different approaches an organization can take. With that, let's jump right in. So to set the scene a bit, in today's smartphone age, as Simon mentioned, we have a wide range of messaging applications, all with different uses and functionalities. But we also have different types of devices, our most common being Android and iPhone, all with different deployment strategies like BYOD, so bring your own device, or corporate issue devices. And on top of all of that, we just have generally a lot more data, right? According to a tweet by the head of WhatsApp in 2020, more than 100 billion messages are sent each day on WhatsApp. Those numbers are likely to have increased over the last 4 years, and the problem we face today is that a lot of these messages are failing to be retained or preserved in the right way. So when it comes to finding the best approach to manage these communications, it goes without saying that corporations vary greatly in size, industry, risk profile, and commercial appetite. This means each company needs a tailored approach that balances risk mitigation, cost efficiency, and business continuity. While policies and procedures, training, awareness, regular audits, etc., are all of high importance, what I want to do is focus on some of the technological solutions out there that help further push an organization into compliance. Now, really, from a tech perspective, you can kind of split it into 3 different categories. 1, mobile device management, otherwise known as MDM. 2, communication retention and monitoring tools. And 3, forensic software, otherwise known as device imaging. So what we'll do is we'll start with mobile device management software. MDM, it's a fairly common software that you may have heard of, and you likely even have it installed on your device. Examples of MDM software include Cisco Meraki, Microsoft Intune, Acronis, and plenty more. And it's technology that's fairly commonplace these days on both corporate phones and BYO devices. But I'm going to keep the coverage of this section fairly light, as these tools are great for controlling phone applications by telling users what they can and cannot download and managing devices. But what they don't do is they don't really do much in terms of retaining messages. While a small number of them can carry out backups of corporate devices or even BYOD devices remotely, they typically cannot preserve the third-party messaging applications that are commonly used for off-channel communications. It's also worth noting that even if you did back up an employee's own phone on a regular basis, and if you were able to capture the ephemeral messaging apps, that would now mean the organization is holding all of the employees' personal chats. That's their personal data, their personal messages, family photos, all of everything. And obviously, nobody would be really happy having all of their data backed up to an organization's infrastructure. Quite frankly, it'd also be a data privacy nightmare. And I'll touch on that in a second as well. So while it's worth noting that this technology is out there and exists, it's not necessarily the best way to achieve an organization's goal of retaining this data type right now. Instead, an easier way of managing and preserving these communications are the comms retention solutions. So for companies that need stricter monitoring and data retention around messaging platforms, this is where comms retention solutions like Movius, CellTrust, Smarsh, and Symphony, and there are plenty more, come in. How these work is that they essentially create a clone application, such as WhatsApp or iMessage, and have a completely separate phone number. That stands separate to the employee's personal chat application. So essentially imagine it as having two different instances of WhatsApp, for example, and it captures messages in real time, even if they're deleted. This is the approach a lot of the financial institutions are taking, and one we're also seeing industries in other sectors increase their adoption in. What would happen is that these tools would then be mandated with appropriate training and for use with clients, amongst employees, et cetera, and all the data would be captured centrally in a location where it can then be either archived or it can be actively monitored for any suspicious activity based on keywords or pre-trained machine learning algorithms. One of the key benefits of this is that you can also keep your work and your personal chat separate. Additionally, other benefits are the fact that it's actually seen as proactive compliance with regulatory standards, obviously alongside appropriate implementation, training, and auditing. It's applicable to both BYOD and corporate devices, and it's obviously beneficial from a data privacy point of view because everything is kept separate. It does have its drawbacks, though. So for one, cost is obviously going to be a thing, and as well as change management challenges when implementing such solutions. There's also potential feature limitations. So because these are not necessarily the actual, for example, WhatsApp application, it's a clone app, some of the functionality may be reduced. For example, there may not be group chats, or certain media items might not be able to be sent between users. And also, it's not compatible with all applications. So there are clone applications for things like iMessage and WhatsApp and Signal, but other applications such as Telegram are not entirely supported at this moment in time. So in addition to that, what happens is this doesn't solve the problem where if you have a bad actor who wants to message your client or another party off a sanctioned channel, they still can, and it won't be retained. So what happens next is, this is where kind of forensic software comes in, because what this does, it is typically used in a reactive manner during disputes or investigations to capture all the data on the device. That's the personal, the work, everything. And while there are other tools that can capture segregated portions of devices, of the data on a device, this is the most kind of, capturing everything is kind of the best approach when it comes to ephemeral messaging applications. And as this is used in a reactive manner in most cases, this isn't seen entirely favorable in the eyes of regulators when it comes to that proactive preservation of off-channel communications, as seen in the financial services sector in the US. But it can act as a last line of defense and is a crucial part of data retrieval during an investigation or even a dispute due to its ability to retrieve deleted items. This technology is known as full file system phone collections. And I'll explain what that means in a second. So you essentially have two types of mobile phone images that can be done when you're copying data phone. You have one, logical, and two, full file system. If we take an Apple device as an example, logical collections are similar to performing an iTunes backup. And believe it or not, you don't actually get that much from an iTunes backup, right? As an example, in iTunes backup, you can't get any Signal data if you have Signal installed on the mobile phone. Now, full file system, on the other hand, this is the technology that's been largely established in the military and law enforcement area, and it's slowly making its way into the private sector. And it's fairly established at this point, to be fair. But they can retrieve items from ephemeral messaging apps such as Signal. It can also retrieve deleted messages, though there's a strong caveat here. The effectiveness varies based on the type of messaging application and the time and activity elapsed since the message deletion. Think of deleted items like your rubbish bin at home. It'll fill up. Eventually, things will get taken out and cleared and deleted. And obviously, the longer you leave it and the more activity happens, the less likely you are able to recover those deleted items. And as mentioned during MDM, that when making a copy of the entire phone, this does open questions around data privacy, right? You are accessing all of the personal data on a device. And while US regulators typically have less concerns on data privacy than European and other global regulators, it still is a very serious consideration to be made when pursuing this avenue. But appropriate steps can be taken to mitigate these privacy risks. As an example, at FRA, we've devised a number of workflows that allow us to collect the entire device and via the use of a number of different search terms, and as well as machine learning tools where we can ensure that only the corporate related data is reviewed while the personal data is segregated or even deleted. Now, while consideration should also be made during investigation or matter as to whether the phone should be collected using logical or full file system, you also need to take into the account jurisdictional considerations. As the technology to image devices is so powerful, it's actually quite banned. It's actually banned in quite a few different countries. Now, it's likely that most of the people attendees on this webinar today, your countries are probably okay, but it is one of a key consideration to make. So as you can see, forensic software can be a pretty powerful tool to uncover deleted items, but it is typically used more during investigations or a dispute, as opposed to being a proactive archiving solution. Otherwise, you'd be imaging / making copies of people's phones for days on end, and it just wouldn't be a productive solution. So to wrap up, 1, a tailored approach is crucial to ensure compliance, reasonable costs, and risk mitigations. 2, comms retention software is advisable for high-risk jurisdictions. That's from a regulatory point of view, and as well as in specific industries. And 3, technology has its limits. So it's crucial to establish robust policies and training to handle BYODs or corporate devices scenarios effectively. But in a nutshell, not all hope is lost with deleted / ephemeral messages. Timely action, though, is needed often to retrieve these items. Now, I will pass back over to Masako, who will go through how you develop the type of robust framework I've alluded to.
There was recently a report from Global Relay, a leading provider of electronic communication compliance and archiving solutions. In their second annual Insights report, 65% of financial institutions are struggling to enforce compliant electronic communication policies. Despite a 15% year-over-year decrease, banning WhatsApp is still the top risk mitigating measures among financial firms, with 44% using them to keep a handle on internal communications. Additionally, 79% of firms are increasingly adopting communication surveillance technology to detect misconduct. It is true that banning messaging application entirely or the use of employee personal devices would be the easiest policy if the goal is to get rid of risks associated with ephemeral messaging features. However, we also understand supplying company mobile devices to employees or banning the messaging applications entirely for business dealing may not be an option. In the earlier section, I discussed the regulators expect companies to consider risks of non-compliance and come up with appropriate solutions that are control-based. In practice, companies can approach this in 2 steps. First, set up policy, and second, enforce and monitor. For the initial stage of setting up policies, we are sharing factors and questions that companies should consider as they navigate this complex journey around ephemeral messaging. First, understand the risks involved. If messaging applications are allowed, whether employee-owned or company devices, how will that affect preservation policy of the organization? Will there be an employee agreement that will allow a company to access employees' own device, and how would that work in practice? If only business mobile devices are allowed to communicate business, what can a company do to ensure employees are not using employee-owned device? How do you respond if regulators request all communication data or information on employee-owned devices because business is being conducted? And how does that collection look like? Once the risks are identified and assessed, companies should update their policies and procedure and consider these questions. Does a company prohibit the use of messaging applications in communicating with both internal and external parties? What about the use of messaging-oriented middleware that allows company to monitor? Would the company monitor activities on employee-owned devices, and how is that stated in the policy? How does monitoring activities look like? Will there be a surprise check to manually access employees' phones or monitor employees' work phone from backend? With a new policy in place, companies' foreminds should be on providing training regarding a new policy. Does a company plan to provide training to employees every time a policy is updated? Does a company remind and chase employees that have not completed training? Will a supervisor hold a separate meeting to discuss the importance of complying with policies related to ephemeral messaging applications, and how often should this team talk take place? How does self-attestation or self-reporting work in events employees realize violation or non-compliance? Will there be a disciplinary action? Once companies evaluate risk of using ephemeral messaging application in their business, update policies, provide appropriate training to employees, the companies can now consider process such as monitoring, investigating, and employee certification to ensure the policies related to ephemeral messaging application and features are aligned. It is perhaps the hardest part of the compliance program, but the company must entice employees to follow the company policy through both incentives and disciplines. How do you incentivize employees to not use ephemeral messaging features when employees use their own device for business? What is the policy regarding non-compliance and violation and disciplines of non-compliance? Will employees receive a verbal warning, or should the first offense lead to immediate termination so the company can set a tone and show the company is serious about the policy? How does a company measure severity of offense that ties to such discipline? How does disciplinary action affect the corporate culture, especially if a strong policy and disciplinary actions might promote fear among employees? If a company receives a whistleblower and other reporting company, if a company receives a whistleblower and other reporting, a company should consider the following elements. What actions to take when employees do not agree companies have access to personal devices, even if the employee agreements has a clause for screening? Will the company use third-party experts in pulling data? What other devices should a company review if prohibited messaging app use is confirmed? For example, checking voicemails, emails, and social media accounts. Will the company voluntarily report the results of investigation to regulators if violation of law were identified? As a compliance program evolves, it is essential that company incorporates continuous monitoring and auditing so that violation or misconduct can be detected. How does monitoring look? Will there be a random check by supervisor or other independent functions such as compliance or audit as employees arrive at the office? Is that legally enforceable in your country? Should the company provide notices regarding such random checks periodically? Will there be a narrow scope monitoring of specific departments based on risks? If employees use company devices, should data be analyzed? If collected, how would that affect the preservation? Lastly, a company can incorporate an annual confirmation procedure so that not only employees are reminded of the company policy, but also for company to learn about employees' use of ephemeral messaging, and at minimum can act as a survey of a sort. Is certification by employee enough? And finally, if an annual confirmation uncovers the use of ephemeral messaging application that is not permitted by company policy, how should that be treated? What else to provide in addition to training? To wrap up, there are many elements companies can consider, and it is important that they approach this holistically and not in silo. Company can also perform benchmark their policy and procedure with competitors. This has an advantage as competitors are often faced with similar challenges and in need of forum to discuss best practice. In conclusion, practical and pragmatic solutions are vital to address these rapidly changing technology landscape. Establish a comprehensive framework and ensure its practical implementation through careful calculation, monitoring, and enforcement. Encourage a culture of compliance and robust internal controls, utilizing technology as a supporting tool.
Thank you, Masako. That was great. I think just in the last 5 minutes that we have, I'll pose one question that we have maybe to Simon. If a company does not have the financial investment for proactive compliance at this stage, what else can they do to meet obligations regulators are requiring?
Yeah, thanks, Nicole. And I may ask Alejandro to jump in a little bit on whether there are some lower cost technologies that could be geared to a company that finds itself in that position, because it's completely understandable that when you look at all the potential things that you could do on a proactive basis, it can be quite a heavy burden. I think what is really important as a starting point is to best protect yourself is to do some form of appraisal of the risk that you as an organization feel that you face in this area. So that's kind of at the very least understanding whether or not off-channel or ephemeral messaging is in fact being used in the organization at all. That might just be to survey your employees, or potentially to look at anything that comes through your whistleblowing line to see whether there's evidence that this type of messaging is taking place. So the first thing is to understand what your risks are. And look, there may be risks that and the regulators have been pretty clear about that, actually, that it's not one size fits all. That you do need to calibrate this according to what kind of exposure you have. And the first exposure you have is the extent to which these types of messaging platforms are being used across the organization on a day-to-day basis. It could be that it's very regional in terms of where your risk is, or it could be that your risk is confined to particular groups within the organization. So by that I mean it may be that it's a sales team in Venezuela that uses off-channel messaging, or just to take an example from my own region here, where WhatsApp is prevalent. It could be that in the Middle East you want to focus your resources. So I think the key thing is risk assessment, and then just trying to gear and calibrate what you do according to that risk. And it may be that if you're in a low risk industry with not very much exposure to this type of activity, that you can gear your compliance program and your costs to that effect. But I think doing absolutely nothing, given the way that the regulators are and prosecutors are positioning themselves here, is something that is difficult to justify, even on the most basic of risk appraisals for most companies. Let me just I know we're kind of running relatively short time. Let me just let Alejandro jump in there and see what he has to add to that.
Yeah, thanks, Simon. I think just to add to, I mean, you make a good point on the risk assessment, and I think if that's all done and then you decide that there is still a solution needed or some kind of technology to put in place, I think not ruling out the kind of comms retention tool would definitely be a mistake. I mean, there is this kind of sliding scale of solutions in terms of how advanced it can get, right? So there are actually far more economical options, and there's different ones that just really leverage WhatsApp APIs and these kind of things. So there are solutions out there, especially if you're comparing, if it's a financial institution, obviously they likely want to be storing their own data on their own premises or their own servers, but you can be leveraging things like SaaS platforms to kind of reduce those costs and have that flexibility that if that risk goes away, you can actually kind of downscale those solutions as well.
Great, thank you, Alejandro. Nicole, do we have any other questions that came in, or should we? Actually, I think we're running pretty close to time, so maybe I'll just take a moment or two to wrap things up. Well, look, first of all, thank you, Alejandro and Masako, for walking us through some of the key areas here. And obviously, unfortunately, this is all we have time for today. But as I think everyone can see, there's lots and lots to talk about here, and things that I think will continue in the future. For those of you that have submitted questions but we've not really had the time or been able to address on this webinar, we'll respond to you directly via email. We obviously hope that you've all found today's webinar useful. And I think, just to kind of line actually in conclusion, which is that it's pretty clear that this world of off-channel communications, coupled with elements of potential ephemeral messaging as well, is very much here to stay and is completely the new normal, and is probably only going to expand. As compliance professionals, I think we must seek to be as proactive as we can in this space, to adhere to evolving regulatory requirements and guidance. And whatever your risk appetite happens to be, I think it's important that you have a framework in place that supports this. So if you'd like to reach out to us to talk about what the right framework is, or what solutions might look like for your organization, you have links to our contact details in the follow-up email to this webinar, along with this recording link, which you please do share with your colleagues. Thank you so much for your time and your engagement this morning or this afternoon, wherever you might be. And I think that wraps it up.
Thank you.
Thanks, Simon.